The Supreme Court just issued a 6-3 decision that, while it may sound procedural and technical, has the power to reshape everyday life in a very practical way. The short version is this: the court moved to rein in the ability of a single federal district judge to freeze a federal policy nationwide through what are commonly called a universal or nationwide injunction. Have you ever watched a major policy get blocked overnight because one judge in one district issued an order that applied to the entire country? That tool is now far more limited. And the reason this matters is that in modern America, huge national fights, immigration, healthcare, workplace rules, firearms regulations, environmental policies, education grants, often turn on who gets an injunction first, where and how broadly it applies. By narrowing that remedy, the court didn't just decide one dispute. It changed the leverage and strategy for almost every major lawsuit against the federal government going forward. To understand why millions could feel affected overnight, you have to understand what universal injunctions did in practice. When a plaintiff challenged a federal action, like an executive order, agency regulation, or enforcement policy, a district court could sometimes issue an injunction preventing the government from enforcing that action, not just against the people who sued, but against anyone anywhere in the United States. That meant a single case could temporarily set national policy while appeals played out. Supporters said this was necessary to prevent obvious illegality from spreading and to avoid a patchwork where rights depend on geography. Critics said it gave too much power to one judge, encouraged forum shopping, and let courts effectively run the executive branch by emergency order. The Supreme Court's new approach aims to push federal courts back toward deciding cases between the parties, instead of using one lawsuit to dictate nationwide policy for everyone at once. The case at the center of this shift, Trump versus Casa, arose from challenges to an executive order aimed at ending birthright citizenship for certain children born in the United States, depending on their parents' immigration status. Several federal judges blocked the order across the entire country. The government asked the Supreme Court to narrow those injunctions, arguing that federal courts were exceeding their authority by issuing universal relief. In a 6-3 ruling, the court sided with the administration on the injunction question, without fully resolving the underlying constitutional fight about birthright citizenship itself. That distinction is important. The court focused on the remedy, not the ultimate merits. In other words, even if a policy is likely unlawful, the court signaled that the response is not automatically a nationwide freeze from a single district court. So what changes now? First, it becomes harder to stop a federal policy everywhere, all at once, through one early injunction. Plaintiffs can still win injunctions protecting them personally, and states can still seek relief for harms they can prove, but the automatic jump from one case to a national shutdown is no longer the default. That means many policies will remain enforceable in at least some places while litigation continues. For ordinary people, that creates a more fragmented reality. Your rights, benefits, paperwork requirements, or exposure to enforcement could depend on whether you are a party to a case, a member of a certified class action, or located in a jurisdiction where controlling precedent already exists. That's why people describe this as rewriting the playbook for governance. It shifts power toward the federal government's ability to keep operating while lawsuits work their way up the chain. Second, the ruling changes what winning looks like at the early stage of a lawsuit. Previously, advocacy groups and state coalitions could bring a case, obtain a nationwide injunction, and effectively pause a policy for everyone, buying time and preventing nationwide impact. Now, the incentive shifts toward broader case structures, especially class actions. The Correas opinion explicitly left room for class action litigation as a way to obtain broad relief for similarly situated people, but class actions have their own procedural hurdles, certification standards, definition of the class typicality, commonality, and the time it takes to build a record. That means the emergency nature of early litigation becomes less decisive, and the ability to organize large groups into proper class litigation becomes more important. For organizations, lawyers, and donors, this is a structural change, less about one dramatic injunction and more about building cases that can survive procedural scrutiny. Third, the ruling is likely to reduce the political and strategic impact of judge shopping, at least somewhat. Under the old incentives, challengers often sought out districts perceived as favorable, hoping for a quick national injunction. Governments did the same, racing to friendly appellate circuits or seeking stays. Now, because the reach of an injunction is narrower, the payoff from finding the perfect district judge is smaller. It doesn't eliminate forum shopping, but it does reduce the immediate national consequence of a single early ruling. At the same time, it increases the importance of appellate courts and the Supreme Court itself, because nationwide clarity will more often come from higher courts rather than from one district court order. The majority's logic, as summarized by SCOTUS' blog, is rooted in the idea that federal courts do not have free-floating power to supervise the executive branch. Courts resolve cases within the authority Congress has given them, and when the executive acts unlawfully, The cure is not for courts to exceed their own power in response. In practical terms, the majority treats universal injunctions as a modern invention rather than an established part of historic equitable practice, and it insists that complete relief is relief to the parties, not necessarily to everyone who might be affected by a policy. That framing matters because it moves the judiciary away from broad managerial control of federal policy and toward narrower dispute resolution. But the dissents raise the alarm in the opposite direction, warning about what happens when unlawful policies can be enforced against people who haven't sued. If only the named plaintiffs are protected, then constitutional rights can become real only for those with the res and legal access to file a case quickly. The SCOTUS blog describes Justice Sotomayor's dissent as strongly worded, emphasizing that without broad relief, unless class actions are quickly built, government policies that are plainly unconstitutional may still operate on everyone else in the meantime. For the dissenters, the practical result is that the executive branch gains room to act first, and the courts become slower and less capable of immediate nationwide correction. This is where millions affected becomes concrete. Think about any federal policy that touches large populations: immigration documentation rules, healthcare eligibility standards, federal workforce policies, student loan rules, firearm enforcement guidance, or grant and funding decisions. When nationwide injunctions were common, one judge could stop a policy nationwide, instantly changing what agencies could do tomorrow morning. Now, changes may roll out unevenly. One group may be protected by an injunction. Another group in a different state may not. One employer may have to comply with a rule, another may not. One family may be covered because they fall under a plaintiff group, another may not. The country could see more temporary patchworks until appellate courts resolve conflicts. This isn't just legal trivia. It's a change in how fast and how uniformly government decisions can be stopped. So what should viewers do with this information? First, recognize that you may start hearing a new phrase more often: class action, as the vehicle for broad injunctive relief. Second, if you're following a major national controversy, don't assume that a judge blocked it means the policy is blocked everywhere for everyone. Ask, blocked for whom, in what jurisdiction, and on what terms. Third, expect more rapid appeals and more pressure on appellate courts to unify national standards. And finally, understand the broader arc. This decision is part of a continuing struggle over separation of powers, how much the judiciary can restrain the executive quickly, and how much the executive can continue operating while the courts deliberate. However you feel politically, that is the real story beneath the headlines, and it's why a 6-3 procedural ruling can change governance in ways that ordinary people will notice in their paperwork, their eligibility, their enforcement exposure, and their day-to-day interaction with the federal state.